Hi, everybody. Welcome to session 23 of Arbitration Bootcamp. We're obviously going to talk about the new ADRIC rules. And this is the 23rd Arbitration Bootcamp. I'm starting to run out of ideas, folks, so if you've got any, let me know. After this webinar, you will get a video recording of the webinar, and you can also find it and my other 22 sessions on YouTube. You'll also get, after this session, a list of all of the Arbitration Matters webinars, just in case there's something there that catches your fancy. You can check it out on YouTube. Just a little bit about me if you don't know me. I'm a partner at Learners. I am an arbitrator with Arbitration Place. And I am not only doing these Arbitration Bootcamp webinars, but I am also the editor and a writer for Arbitration Matters, which is a series of blogs posted to my website, www.arbitrationmatters.com. And it provides summaries of arbitration cases from around the country and commentary. The blogs go back to, I think, 2017, and there's over 800 of them at the moment. If you'd like to subscribe to a newsletter that I prepare with the case summaries, it'll arrive in your inbox. It's free. And so you'll get those summaries on a regular basis. If you just want to tune in to the website whenever you're looking for a case or want to do a bit of research or want to see what's happened recently, they're posted there first. So today, as usual, I will have you out of here before 1 o'clock, and I have a Q&A box open. If you've got any questions about what I'm going to talk about today, I'll try to answer them as they come up, but if not, I will check before the end of the webinar. And I will do my best to answer questions about the new ADRIC rules. They are posted on the website already, although they don't come into effect until March the 1st. And because they're so new, I may not know everything about them, but go ahead and ask your questions anyway, and I'll do my best. So, as I said, the rules are effective as of March the 1st. And what that means is that arbitrations that are commenced as of the date the rules come into effect are governed by those rules. And I do think that, and we haven't had this experience obviously yet, there may be people whose arbitrations started under the old rules and may want to move them into the new rules, and that will have some logistical issues, which no doubt we will hear about. So why am I talking about these rules? I think that you're going to want to use them because I actually think there's a lot of really interesting updates, and I hesitate to use the word update because what this really is a modernized, re-envisaged set of Canadian arbitration rules. And they really do focus on the lessons that we've learned and the experience that we've had in modern arbitration practice, where the focus really is greater efficiency, greater speed, and the differences between arbitration and litigation are really enhanced and highlighted. The rules provide practical precedents that I think that you're going to want to use and you'll find very interesting, and I'll talk about those in a moment. And the rules also provide greater flexibility than the old rules did. They are truly customizable, and I'll give you some examples of that in a moment. But before I get there, I do want to let you know that the new rules were drafted by a committee headed by Bill Horton, Jim McCarthy, and Jim Musgrave. And the reason I mention their names is not only to give them credit, but also to give you that information if you're using the rules and you have a question or you have a suggestion about how they might be improved or something that needs to be tweaked. Please do send that along. You can also send those comments to me. We really want to know how they are being implemented in practice and how they can be improved. And no doubt there are things that the committee hasn't thought of. So your feedback will be extremely useful. The key philosophy behind the rules and what they're designed to achieve is that they're customizable and they should be adapted on a case-by-case basis so they can be tailored to the particular needs of the dispute. And I think that the greatest indication of that is that these rules are a la carte, as we call them. There is institutional support only when the parties need it. So there isn't, for example, um, institutional fees that required are to be paid as soon as the arbitration is commenced, even if the parties don't later need assistance from the institution. The payment gets made to ADRIC only when a party needs a particular service. The rules explicitly impose an obligation on the parties and their counsel to work with each other and cooperate to meet the objectives of the rules, which are to just speedy and a cost-effective determination of the dispute between the parties. And while this may seem obvious that that is the objective, the fact that counsel are also included in that and that it's an explicit rule, I think is a reminder to everyone involved in the arbitration that that's the objective that we're all trying to achieve. And that's why parties sought arbitration in the first place. And it also gives a very clear indication to parties that if they don't cooperate in this way, this is something that the arbitrators can use in assessing costs at some point during the arbitration. One of the little tidbits too that I think is important before we get to the substance of the rules is there's clarification of the term seat, which vexes so many people, both people involved in arbitration and parties who are unrepresented and to whom the rules, we hope, will also be accessible. And the definition of the word seat is not the venue, obviously. It's the legal location of the arbitration whose laws govern the conduct of the arbitration regardless of the physical or virtual location of the arbitration hearings and meeting. So the use of the words legal location are intended to signal to parties and counsel that we're not talking about what people think of as the venue or the place of the hearing. This really is a different term, and it's highlighted here, I think, for a very good reason. What I'm also going to get to, which I think you're going to find really interesting and useful, is the precedents that are found in these rules. The most important of which are the checklist that can be used by parties and arbitrators when preparing the first procedural meeting. The checklist has virtually everything that might need to be addressed at the first procedural meeting, and more than virtually every case will need. And the PO number 2, there is a standard precedent sample PO. Did I say number 2? PO number 1. So it gives a precedent for parties and counsel to understand what generally is to be included in PO number 1. And there may be issues in PO number 1 that the parties don't want to address right then, want to deal with down the road. And there is a list of things and provisions that may be useful later on. So the first place to start when I refer to the specifics of the ADRIC new rules is conflict disclosure processes and standards. And I start with this because this is top of mind, particularly for arbitrators, because of the Aroma and Vento decisions and the recent Court of Appeal decisions. And those are decisions that virtually everybody is talking about because they address both the duty to disclose and the justifiable doubts or reasonable apprehension of bias test. So the ADRIC rules actually address these two issues. They affirm the requirement that arbitrators must and remain independent and impartial. And the reason that is important is there are some domestic acts which allow the parties to opt out of either independence or impartiality or both. And the drafters of these rules view the importance of the arbitrator throughout the arbitration as being both independent and impartial as absolutely critical minimum standard conduct expected of an arbitrator. So opting out of this standard is not allowed. There are other provisions in the rules that the parties can opt out of, but not this fundamental standard. The rules adopt the standard of conflict or reasonable apprehension of bias from the UNCITRAL rules. So the rules provide that challenges to arbitrators may be made if there are circumstances that give rise to justifiable doubts as to their independence and impartiality. So this is the applicable standard, even though some of the domestic legislation refers to the reasonable apprehension of bias test, which I think the most recent Court of Appeal decision in Aroma clarifies is the same test, is the justifiable doubts test. So the rules do not seek to change or weigh in on what that test means or how it is to be applied. So to the extent that the courts are increasingly using the IBA guidelines on conflicts of interest in international law, the rules do not interfere with the development of the law in that regard. There is one clarification in the ADRIC rules on this subject, which is new. And that is arbitrators explicitly cannot be disqualified or challenged because they and another arbitrator, counsel, or a party are members of any professional, legal, or arbitration-related association or body, or they have jointly participated in a program, project, or activity of any association or body. And this resolves a question that parties and counsel and arbitrators have had over the last couple of years. And that is, how much do I need to disclose about the fact that I saw an arbitrator, a fellow arbitrator or counsel at an arbitration related event where we were members of the same organization or we spoke on the same panel? And this is a really critical issue that often arises in Toronto, Vancouver, Montreal, some of the bigger arbitration venues. Because it is a small community. Most people know one another and come across one another on a regular basis. And there are questions about to the extent to which disclosure needs to be made and what criteria can be used to determine reasonable apprehension of bias and whether these kinds of relationship satisfy a ground that could be relied upon. And so this clarification, I think, is pretty significant, particularly for people who are doing work either in small places or where there are a few arbitrators who are chosen on a regular basis, for example, for franchise law disputes. One of the new issues that is dealt with in the new arbitration rules is this concept of party disclosure, which I find often gets overlooked at the beginning of discussions about terms of appointment, and that parties and counsel don't often consider their own obligations of disclosure. Most of the focus is in on the arbitrator's disclosure. And so there is a new requirement of party disclosure in the arbitration rules. This disclosure is required before the arbitrator is appointed, and there is ongoing disclosure. And so this creates kind of a symmetrical disclosure obligation. The information to be disclosed includes other individuals or entities with a significant financial interest in the result of the arbitration, the expected witnesses, and I often see counsel kind of cringe when we talk about the idea that expert witnesses must be disclosed, because one of the very big differences between arbitration and litigation is that expert witnesses and their reports are often produced very early on in the process rather than close to the hearing. Individual counsel and law firms, of course, and any other information that would assist the arbitrator in assessing whether to accept an appointment or what circumstances to disclose. So an example is whether a witness or a party is somebody that the arbitrator knew when they were a child, that sort of thing. So it's clearly stipulated that there's ongoing party disclosure and that the parties share this obligation, which I think is a real improvement in clarifying the obligations of various participants in the arbitration. There is, of course, arbitration disclosure, which is nothing new, and there's a form that is to be filled out as a precedent in the ADRIC arbitration rules, and it contains a standard declaration about independence and impartiality. The result of all of this, in the view of those who drafted the rules, is that it streamlines the appointment processes and reduces the potential for challenges, because the responsibility is shared and there is an expectation that all of these issues are dealt with in a way that's contemplated specifically in the rules before there's an appointment. So it should make appointments take place more quickly. So that is, I think, one of the important issues that the new rules address. Another one is what we're calling the customized or a la carte support that ADRIC provides as an institution. And what this means is that institutional support is there only when needed and may not be needed at all, which is to say that the parties may proceed using the ADRIC rules and never need the assistance of ADRIC as an institution. The reason I think this is important is that there are some counsel, some arbitrators, and some parties that are hesitant to use well-known institutions mostly because they don't understand them. But there is some concern about the institutions perhaps being too overly involved, causing delays, that sort of thing. So this appeals to people both who want institutional support and also those who are involved in an ad hoc arbitration and will decide later on whether they require or any assistance from the institution. The new ADRIC rules provide just the services that are needed, which means there's no case initiation fee at the outset and no need to copy ADRIC, for example, in the notice of arbitration. So the arbitration can take place entirely insulated from the institution if that's what it requires and that's what the parties need. But there are still the services that you can expect from the institution, and those are paid independently. And there's a schedule of fees in the rules which lets you know how much each of these services will cost. So of course, ADRIC will assist with tribunal formation. There is it will help appoint an appeal tribunal. So one of the innovations in the rules that you see in other rules but is not common is the ability for parties to opt in to an appeal in writing normally heard by a panel of 3 arbitrators appointed by ADRIC. There are also some changes to the arbitrator appointment process. There is actually a protocol that is already on the ADRIC website, which explains how arbitrator appointments are made, what are the criteria, what are the process, and who is making those decisions. And there is a arbitrator appointment committee that has already been constituted. Names either are or will be on the website so that everybody knows who's making the decisions. The members of the committee have experience from across the country. So there will be experience about how arbitration is run in different contexts, in different markets, and also greater knowledge of the people who could have the expertise that is necessary to determine a particular dispute. Then another, I think, important change to the ADRIC rules is the elimination of the distinction between an international and a non-international, or what we often call domestic dispute. So the new ADRIC arbitration rules apply equally to international and non-international rules, what I call, if you're a Lord of the Rings fan, I call one set of rules to rule them all. The old ADRIC rules, if you ever used them when you were involved in an international dispute, were, to be frank, very difficult to understand because it wasn't clear what rules were to be used. In some circumstances, it was the ADRIC rules. In some circumstances, it was the UNCITRAL rules. The current ADRIC rules make it very clear. The ADRIC rules apply, and this eliminates any disputes about whether the dispute is international or domestic. You'll remember that that is an issue that was central to the Uber case, and that issue went straight up to the Supreme Court of Canada, along with some of the other issues that people are more familiar with. But this eliminates a significant upfront dispute that may arise. There is also, as I've said, an enhanced arbitrator appointment process. So the fact that this protocol is published on the website and there is an appointment committee who's identified there is a significant advance in the transparency about how the appointment process takes place in institutions. The the way that arbitration appointments are made is that the information that is on the ADRIC website is used. So if anybody here is looking for appointments by the ADRIC appointment committee, the best thing you can do is to update or create a new profile on the ADRIC Connects portion of the website. That is the same information that the arbitrator appointment committee will use to make appointments, but that information is also available to any member of the public. So even if parties are not consulting with the ADRIC website for ideas and they have certain arbitrators in mind, if those arbitrators are on the website, they can get more information about those potential candidates. What are their areas of expertise? Are they willing to travel to do arbitrations, that sort of thing. And so this is a really important thing because I know that a lot of institutions try to emphasize the need for bios to be posted. And most of us have bios in a whole bunch of places that don't get updated on a regular basis. But it's absolutely essential if arbitrators would like to be appointed that this website bio be up to date, as complete as possible. And that is the place the committee will look to make appointments. The next important part of the updated rules is an expedited and independent and integrated arbitrator challenge process. So challenges are decided by ADRIC. There's nothing new here. They don't go to the court. What's the process? ADRIC appoints a challenge adjudicator, and I have to say that the adjudicator term, when you look at the rules, doesn't mean anything. We use the language because we were using the words arbitrator too often and it was becoming confusing in some contexts. So the adjudicator is nothing other than an arbitrator in this context. So what is really novel is there are standard terms of appointment that apply when a party is challenging an arbitrator and bringing an application for appointment of an interim arbitrator. Both of these applications are dealt with expeditiously, and I think that's a pretty obvious proposition when you're talking about the appointment of an interim arbitrator. But ADRIC is treating a challenge to an arbitrator with equal importance and with equal expediency. So this is to be compared with what happens, for example, when one goes to the courts and seeks the challenge of an arbitrator, and you have to fit into the court schedule, and this obviously is affected by all of the court delays. So ADRIC is going to ensure that the challenge applications are dealt with very quickly, and one of the ways it does that is a standard terms of appointment that the parties will see before the challenge is made, and any arbitrator who's considered for appointment will see it as well. So there is no negotiation that happens between the arbitrator and the parties, which potentially slows down the appointment process. And the terms of appointment contain all of the terms that you would expect to see in your standard terms of appointment. The challenge to the arbitrator is normally dealt with in writing, and that's one of the ways of expediting the process. If parties would like to have it dealt with by oral submissions, that's also available. And one of the novel provisions here is that any party can choose to have the tribunal be constituted among 3 arbitrators to deal with a challenge. There are some challenges that are so significant in an arbitration, so important, that one or both parties may want the decision to be made by a tribunal of 3 rather than 1 arbitrator. I'm now getting to what I think is the most important innovation in the rules, and that is the checklist precedent for the first procedural meeting and the sample procedural order number 1. So the checklist in particular is a multi-page document that sets out all of the issues that the parties will want to discuss or consider before the first procedural meeting. So things like, is there a jurisdictional issue? Is there an issue about whether the tribunal has been constituted? And a whole host of other things that many of us may not have thought of, in fact, and some of them may not be relevant. But both parties and arbitrators have an opportunity to look at these before the first procedural meeting, which streamlines the process and allows counsel to consult with one another and get instructions very early on. Then there is a first procedural order precedent, which is part of that process and allows parties and counsel and the arbitrator to discuss what kind of a process would work for this dispute. And you can cut and paste the PO number one to use what is relevant and eliminate what is not relevant. And it also provides a sample timetable so that parties can appreciate how quickly they can get a hearing. And if they eliminate certain steps, that almost also fast forwards things. So I think that's actually a really important part of the rules that I think you and counsel will use, even if you're not using any of the other rules, or even if you don't need any ADRIC support. Then there is access in the rules to an expedited, simplified procedure and also med-arb. The former is not something that's novel, but what is atypical is that the simplified procedure doesn't necessarily kick in because of the monetary threshold of the claim. The consideration about whether a matter should be determined under the expedited rules is essentially how complex it is. There are some very large matters, high value matters that are not actually that complicated and don't raise a lot of legal issues. Those can be dealt with under the simplified rules, and they will fast track the matter very quickly. Similarly, there are some smaller value arbitrations that are quite complicated and may not be suitable for simplified rules. But another reminder is the opportunity for med-arb. There are separate med-arb rules that were generated by ADRIC and are already in existence, and they're a few years old. But the idea of med-arb is increasingly becoming important as commercial arbitration counsel and arbitrators consider them. We know that they're very common in the family law bar, but they're less common in the commercial arbitration context. I think that's going to change. And this is a reminder that parties and arbitrators can consider integrating in the arbitration a med-arb process. So while some parties would like a mediation opportunity to be built into the timetable, having a med-arb process available also allows parties to exit the arbitration processes at any point in time and get into a mediation process and then step back onto the arbitration process. And if you want to know more about the benefits and the risks of the med-arb process, I did do an arbitration boot camp on this process in which I interviewed David McCutcheon, who is somebody who uses med-arb very often. He's very skilled in it, and many of you have probably heard of him in that context. The model compressed procedure under the expedited rules, I think, is also something that can be used even if what you're trying to do is simply shortcut a regular proceeding. So there's a cut and paste element to the rules here, which counsel and the arbitrator will want to and should take advantage of in order to make sure that the process runs as swiftly as possible. Another element to the new rules involves something that many counsel and many arbitrators may not have even thought of very often, and that's the post-award recourse to the arbitrator that may be made. Certainly, it's provided for already in some of the legislation, and what we normally think about is that recourse is available for calculation errors or slip-ups or omissions, that sort of thing. And the right under the legislation is very restricted. And what that means is, in the view of the committee that drafted these rules, is there's real opportunity for frustration if it's very clear that as a result of human error, there has been a mistake in the award that could clearly be rectified, and the party complaining is required to then make a court application, which causes delay, and that is prejudicial to a party seeking to enforce, et cetera, et cetera. So the rules provide an expanded right for parties to seek a variation, clarification, amendment of the award, and doesn't foreclose the rights of the parties to take that to the court if they need to. But recognizing that parties want a finite self-enclosed arbitration process for the most part, because again, that's why they chose arbitration. The rules provide a greater opportunity for the arbitrator to correct something that obviously should be corrected. And the right of appeal, which I've already spoken about, is, I think, essential. And I think it's going to be more common as time goes on, not just because of privacy and confidentiality considerations, which of course are usually primary when people are considering arbitration, but because of the delays in the court process again. And parties can request of our ADRIC to appoint a tribunal of 3 arbitrators, and that is in fact the default position in the rules. There's a default position that there is no appeal, but if there is appeal, it will be done in writing by a tribunal appointed by ADRIC, and there is no appeal from the award issued by the appeal tribunal. So this allows for an opportunity to have a second, third set of eyes, but also ensure finality and have again the arbitration a self-contained process. If an appeal is permitted, it's on the basis of an extricable question of law that is material to the outcome of the case. This can hopefully avoid some of the challenges that appellants are experiencing right now in having the courts decide what is an extricable error of law. Of course, some of that is because appellants would like to have that right broadened. Respondents would like to have that right narrowed. And so the addition of the language to the extricable question of law that is material to the outcome of the case makes it very clear to the parties that the right of appeal is very narrow. For parties who choose this option, the process is very efficient. It starts within 20 days of delivery of the award, unless the parties agree otherwise. The appeal proceeds entirely in writing, unless the parties agree otherwise. A panel of 3 arbitrators is appointed for this purpose, and the goal is to complete the appeal within a 3-month period from the notice of appeal. This, of course, strikes a balance between party autonomy and finality and flexibility in the arbitration process. It preserves privacy and confidentiality, and it is efficient because of the timelines that cannot be beat in any court. The last clarification, which I think is really critical, and it is something that we're starting to see again more and more, and that is, what do the parties do where one of the parties defaults in participating in the arbitration? It's much clearer, of course, when the applicant, claimant, chooses not to participate any longer, but it's less clear what happens when the respondent chooses not to participate. We all know that the arbitration may proceed and an award may be made against the respondent who does not participate. But what does that mean? How does the tribunal ensure that the respondent who's not participating is dealt with fairly and that the award is as free from challenge as much as that is possible? So there is a rule that addresses that and makes it clear that the arbitrator or tribunal are to continue to give the defaulting party notice of what's going on in the process and an opportunity to make submissions at every step of the way. However, the new rule provides that there will be no extensions of time offered to the non-participating party, and that the award may be granted in the absence of a party. Now, of course, there may be a responding party may request leave for an extension of time, but this is something, it's very clear that this is something that requires leave, and the default position is that the arbitration proceeds on schedule in the absence of the defaulting party. So I don't see any questions in the Q&A box. I will give you an opportunity to make them, but in closing, You've got a few minutes now. This is not an update. So when you look at the new rules, do not expect some tinkering here and there. This is an effort by the committee to really change the approach of arbitration, to modernize it, and to address the specific issues that commonly arise in arbitration. And it reflects the experience of, I think there were 15 members of the committee, both arbitration counsel and arbitrators, who raised issues that we thought were not reflected in the old rules and should be addressed in these rules. So we hope that the rules benefit from the experience of those who are on the front lines. It's practical. The new rules are practical. I've already told you about the precedents. There's the checklist for the first procedural meeting. There's the first procedural order. There's the party disclosure requirement and a form that can be used to make that disclosure. There's the standard terms of appointment where the process is to be expedited, challenging the arbitrator or the appointment of an interim arbitrator. And there is efficiency. This a la carte plan and process allows parties to opt in or opt out of institutional supervision. So the next arbitration bootcamp, which I'll get to now because I don't see any questions, is April 17th at noon. I'm going to skip March because I know there are many people on vacation, and I'm going to talk about how to expedite an arbitration using all the tools. And many people will scratch their heads and say, well, why do you need to talk about how to expedite an arbitration? Because we all know that the objective is that arbitration is to be more fast and expedient and efficient and cost effective than litigation is. But there are ways that arbitration too can get bogged down. So counsel and arbitrators must be familiar with ways in which the arbitration can remain on track and case management can be used to ensure that the arbitration from beginning to end can move as quickly as possible. And I know counsel who don't practice an arbitration very often can be surprised to find out that an arbitration, even a very complex one, can go from beginning to issuance of the award within a few months, depending on everybody's scheduling and the process. It's not unusual to have a case go from beginning to end within 6 months. That is clearly not something that our courts can offer. So again, I've got a question. I'll read it out. Are there transition rules for arbitrations commenced prior to March 1st? Apologies if you've covered this. Is there an obligation to correct something done previously that does not conform to new rules? So I'll answer the first question. The rules provide that the March 1st version of the rules applies to all arbitrations where the parties buy into the rules, where the arbitration is commenced on March or after March the 1st. So either by notice of arbitration or by some kind of submission to arbitration. So arbitrations that are started before that date are governed by the original earlier rules, unless the parties somehow come to an agreement that the new rules are to operate, and then they'll have to figure out how to decide their process given what may have already occurred in the previous. If you're somebody who's started your arbitration on February the 28th, for example, and nothing's happened, then the parties can opt into the new rules, and that'll be very seamless, I'm sure. The second question is there an obligation to correct something done previously that does not conform to new rules? I think my question, your question was answered by my last answer, which is there's not an expectation that parties will be governed by both sets of rules, which would obviously create confusion. They can, of course, design their own rules, but that's not what the ADRIC rules provide for. Well, thank you very much for participating. I don't see any other questions, so I'll wish you a good day. And if you're going on holidays in March, have a great vacation. So I'll see you in April. Bye.